Okie dokie. All right. Well, everyone, welcome to the Privacy Exchange Community's show and tell with our very special guest, Jennifer Tierney. Jennifer is an experienced Privacy Plus leader with a passion for data protection and AI ethics. She is the VP of Privacy, Compliance, and Risk at Brandwatch, which is a SaaS provider. Jennifer works with the legal team to apply global privacy and data protection regulations and oversees the enterprise risk management program at Brandwatch as well. So today, our topic is about negotiating data processing agreements and including the responsible AI new topics that's been all the rage in the last few months, but particularly from a SaaS provider's perspective. So for those of you who are going into negotiations, this is a look from the other side. So today we'll spend the next 25 minutes or so together. Jennifer and I will have a quick discussion for about 10-15 minutes, and then we'll open it up to audience Q&A. All right, so let's hop in. Okay, first up, Jennifer, regarding data processing agreements, I'd like to start off with a more foundational question about why it's so important to get your DPAs right and why it's worth investing time at the forefront to do this.
Yeah, so for me, the DPA is really this, it's a document that so many different people are going to need to refer to at different times throughout the relationship between the two entities. And if it's not quite right, then there's going to have to be a lot more back and forth between those two entities. There's going to have to be clarification. There's going to be renegotiations. It's so important that it's clear what the relationship between the two entities is and what the relationship with the data is. And so often that we see people wanting to use these generic DPAs that don't really take into consideration the specific data or the specific relationships we're talking about. And then you get into these scenarios where it's just questionable. What do we do in this situation? And I'm not a lawyer, but I work with our full legal team, and I don't want to be in a position where somebody's essentially asking me for legal advice. How do I interpret this? I want the DPA to be so clear that no matter what they're doing, they can refer to it and know, and I want my MSA and my service appendices to be the same. I want them to always be so clear that no matter what they're doing, they can take their legal team, refer to those documents, and answer their own questions. So that's like my goal.
Oh my gosh, I love that. And I also love that you mentioned you're not a legal professional, and the reason why you want this tight up front is so that there's no questions on either side, and you can just reference this very tight agreement.
Yeah.
Okay, so another question for you. So from a SaaS company's perspective, when you are negotiating with prospects and customers, what do you find are the most common issues that, require a discussion that forces you to negotiate a bit?
Yeah, so so frequently we have these disconnects between what kind of data and what kind of processing we're talking about. And sometimes the people on our customer side who are reviewing the documents have a totally different understanding of what kind of data it is that we might be processing, or how we might be processing it. And that's kind of where the biggest issues come in, is that the people who have to look at the documentation don't actually know what the product does or what kind of data the product is analyzing, what we're processing on a customer's behalf versus what we process on all customers' behalves, which means our relationships with those data are different. It's the difference between being a controller and being a processor. And so we have these scenarios where we'll be asked about, well, can't we just agree to be a controller in all of these scenarios? And then we have to pull way back and explain, well, this is why we wanted to use our DPA, because it explains, what the different types of data are, and what each of our relationships are in, when we're thinking about the data. And getting that alignment can often be really, really hard, especially with larger customers, with enterprise level customers, where you have these very, very big legal organizations or privacy organizations that are across different regions. Getting that alignment can be really challenging, especially when you're communicating asynchronously. So there are many times when we sort of have to say, okay, you know what? This needs a phone call. We need to get on a call with all of us at once so that I can explain very clearly what it is that we're talking about. And usually a 15-minute phone call clears all of that up really quickly, which is great. So I'm glad that we can still do that.
Yeah, I'm curious. So your customer in some instances is asking to be a controller when we're asking you to be
Sorry,
a controller?
yes, they're asking to be a controller and for us to be a processor of data that we are controllers of. So like in our situation, I don't want to talk a ton from like my business's perspective,
Yeah.
but in some situations, like our company does social media analytics. So we collect all kinds of social media data from all different places and we give it through a database, the same way like Google would be giving when you search Google, they're giving those results to anyone who types in, right? So they're the controllers of that data. The argument would be me as the searcher in Google, I'm the controller of whatever data you show me because I asked to see it and then you showed it to me. And that doesn't really make sense. So having to explain that that difference and how all that works can be difficult because usually the person you're talking to, the buyer, doesn't often understand privacy. And so making all of those connections and having it be clear, one of the biggest things for me is I have created a ton of resources that explains the DPA, that have FAQ documents, like a ton of them, so that I can send all of that up front and explain this is how all of this works. Give it to all of the people who need to understand, and then hopefully you'll understand enough. And if you have questions, come talk to me. And so, because it's really important to me that everyone who's going to be using our product understands what their responsibilities are, and understands the data we're talking about and how to treat it safely and properly. And there are just so many disconnects in that system. The person who signs the contract is almost never the user, right? And so making sure it's clear to everyone is one of my biggest priorities.
I love that you create a FAQ to go
Yeah.
along with this. This sounds like the most like joyful negotiation process where
I
like
try
you
really hard to make it fun.
yeah, like you have a basis of understanding that's maybe in plain language so that it's not like all the legalese. And I'm taking a major takeaway from that, Jennifer. Thank
So
you.
good.
One thing that I definitely wanted to cover today is AI data processing. This is the new kid on the block. There's still a lot going on. There's a lot of misunderstandings as well. So I'm curious in your experience, what have you seen the biggest challenges with AI process data so far?
Yeah. So I think that because AI is such a moving target, and is so we don't really know what's going to happen from a regulatory perspective. Legislation is just so new. It means that there's a lot of what's the right word? Simultaneous, work streams, essentially, right? And they're all moving at the same time and all very quickly. And so what I've run into the most is this misunderstanding about when we say AI, what does that mean? What does it mean in our industry? What does it mean in your industry as the customer? What do you mean when you say AI? We've been, as a company, and many companies that do any sort of analytics have been using AI for at least a decade, but not the kind of AI that blew up at the end of 2022. That's generative AI, which is different. It's still all just data and algorithms. Like that's all any of it is. But explaining to folks, well, we have to use this data that we have used for years to do natural language processing, which is what you're paying us to provide you with. we need to use that data for this purpose. Otherwise, we can't provide the service. Yes, it's AI, but it's this version of AI. And so now I'm finding having to create very robust resource pages for customers, for vendors, for our data providers that explain very clearly what is it that we do when we bring this data in. What are we doing with it? Are we training with it? In most cases, no. We use models that already exist. But we do run those models on the data that we're given by our customers or from social media. And that allows us to, so it's another layer of explanation. And I think once people understand, then it's less concerning. But so many of our customers now are the same way it happened with GDPR. We're now seeing all these new questionnaires with questions that often are completely irrelevant to the kind of work that we do, and trying to explain like what you're asking about is not relevant to what we do can be hard, because I think sometimes those questionnaires, while coming from a very good place, the people asking those questions don't always understand what those questions truly mean. And so it's because sometimes it's like the security team is like, send this over to them before you buy it and have them answer all these questions. Okay, but this is not that product. So it's definitely much more time being spent on communicating clearly to everyone so that we're all on the same page. So yeah, I'd really love just global definitions for AI that everyone agreed on. That would be great.
Yeah.
One
So this
day.
is fascinating. So some of my takeaways are that definitions are really still not an agreed upon thing in these negotiations. So you have to spend a lot of time defining from your perspective what that means, but also what it means if they say no. So
Yeah.
like, this is how we use your data. This is the model we put on top of it or run it through. We're not training, blah, blah, blah. I kind of imagine in this DPA, like having that little information button you hover over and it
Yes.
explains.
Right.
It's kind of the
Yeah.
picture that came in my mind when you were saying that. Thank you for explaining that.
Yeah.
I have two questions before we open it up to the audience. In your experience, this is a negotiation. So what are some areas where you feel like you have some more flexibility to meet someone else versus no flexibility?
Yeah. So in most cases, I try really hard to be so often the legal and privacy world is referred to as like the Department of No, right? And I do everything in my power to not be that. So instead, I try to say yes starts here, So like, let's start with what we have and get ourselves to yes. So in negotiations, there are most things I try really hard um to listen to what it is that they're trying to accomplish and then get them to good enough, right? There are only a few things that are like hard and fast no's, which is like if there is a serious misunderstanding around our relationship to the data, I will continue to have that conversation until the cows come home, until it's really understood clearly. Like, no, you cannot be we cannot be your processor for this data. We are absolutely a controller in this scenario. And that's one thing that confuses a lot of customers, is that our DPA has a C2C section, a controller to controller, and a controller to processor, because I want it to be very clear to you, the customer, when we're each a controller versus a processor. And so some people are like, well, you don't need a DPA for controller to controller. I'm like, yeah, but at least now you know which scenarios cover which relationships. And I had another thought, but it's left me.
It's okay. I do have a related last question
Yeah.
before we open it up, and it's kind of going along the topic that you're going on already, which is, what are some win-win suggestions that just help this process go more smoothly for both parties? Any
Yeah.
advice?
Yeah, I think if you're looking at a vendor and they have a DPA, unless their DPA is clearly a really bad template, or is obviously deficient and not up to date with current legislation, you should use their DPA because that DPA almost certainly represents their product, whereas a generic vendor DPA from a customer is most likely not going to cover the specific scenarios that the vendor's DPA will cover. So at least start from their DPA, right? If there's certain language that you need to work in there because it's just a requirement for your business, then in most cases I'll add things in. You can redline in things that are specific to your business. I'm always happy to, like, a lot of companies, I find there's that notice requirement, right? The requirement to notify within 72 hours after becoming aware of a breach. And my
Questions I saw